Hello everyone, good morning to all. Welcome to the new session of our e-learning class. I am Ranjan Mishra, lecturer of UN Autonomous College of Science and Technology. Today I am going to discuss a subject that is relating to business and corporate law. So on today's discussion we are going to discuss a chapter that is relating to capacity of parties. So we will discuss one by one everything relating to capacity of parties, who are the parties, they are competent to create a valid contract, and what are the rules relating to that different parties. One by one we will discuss everything. Listen carefully and watch my video. So first we will discuss what do you mean by capacity of parties. Introduction. The parties who enter into a contract must have capacity to do so. So capacity means competency of the parties to enter into a valid contract. According to section 10 of the Indian Contract Act, an agreement becomes a contract if it is entered into between the parties who are competent to contract. So capacity of party is one of the essential element of a valid contract. We have already discussed the various essential elements which are laid down under section 10 of the Indian Contract Act, and a capacity of party is one of them, that essential contract or essential element of a valid contract. So the parties to a contract must have competent. If the parties to a contract are not competent or they are not the capacity to enter into a contract, then the contract is not a valid contract. So in order to create a valid contract, the parties must have the competency or they have the capacity to enter into. Otherwise we cannot call as a valid contract. So who are the parties they are competent? Now we are going to discuss. According to section 11, every person is competent to contract who is the age of majority, according to the law which he is subject, who is of sound mind, and who is not disqualified from contracting by any law to which he is subject. That means section 11 says everything relating to capacity of parties. The parties to a contract must have capacity or competency if they are having majority. That means who is not a minor person. That means who is the age of 18 or more than 18 years of age. That party is competent to create a valid contract or to enter into a valid contract. Then the second one is the party who is of sound mind. That person is eligible to enter into a valid contract. And the party who is not disqualified from any law or contract to which he is subject, then that party have the competency to enter into contract. This is described as per section 11 of the Indian Contract Act. So section 11 declares the following person to be competent to a contract. The first one is minor. That person is incompetent to a contract. Person of unsound mind is also incompetent to a contract. Then person disqualified by any law to which they are subject. That means when a person is declared as a minor, that means below 18 years of age, that person is incompetent to enter into a contract. And when a person is of unsound mind, that means the mind is not in sound position, that person is also declared as incompetent to a contract. And the third one is when a person is disqualified by any law to which they are subject, that person is also disqualified or incompetent to a valid contract. So we will discuss everything, the minor, person of unsound mind, and persons disqualified by law. First we are going to discuss minor. According to section 3 of the Indian Majority Act 1875, a minor is a person who has not completed 18 years of age. Indian Majority Act 1875 says that a person is declared as a minor person who has not completed his or her 18 years of age. But in certain cases, a person is declared as a minor unless and until that person attains 21 years of age. So in following cases, if the person attains majority, then after 21 years of age, that person is declared as a major person. The first situation where a guardian of a minor person or property has been appointed under Guardians and Wards Act 1890. So this is one situation when the person is declared as a minor unless and until that person completes 21 years of age, and that is the guardian of a minor person or the guardian of the property of a minor person has been appointed under the Guardian and Wards Act 1890. The second situation where the superintendence of a minor's property is assumed by a court of wards. That means everything that is under the court purview, and in that case the person continue till 21 years of age to become a major person. These are the two important situations. One is when the property of the minor is appointed under Guardian and Wards Act. The second one is when the superintendence of a minor's property is under the control of a court. So now we are going to discuss what are the various rules or agreement relating to minor. The position of a minor as regards his agreement may be summed up as under. The first one is an agreement with or by a minor is void and inoperative ab initio. This is the leading case that made between Mihri Bibi versus Dharmadas Ghosh. So agreement with a minor is declared as a void ab initio. Ab initio represents starting from the very beginning. That means we said that minor is not capable to enter into a contract or to enter into a valid contract. Minor person is incompetent. So when a minor is incompetent to enter into a contract, agreement with a minor person is declared as void agreement, and from the beginning when any person creates agreement with a minor person, then that is declared as a void agreement. So that's why it is written as agreement with a minor is void and inoperative ab initio. Ab initio represents from the very beginning. The second rule relating to minor, he can be a promisee or beneficiary. So minor can be declared as a promisee or minor can be declared as a beneficiary. Third, his agreement cannot be ratified by him on attaining the age of a minority. So during the age of a minority, if minor person makes any agreement with any person, that agreement cannot be ratified. That means that cannot be changed even if that person attains the age of a majority, or when the minor person attains the age of a majority or that is declared as a major person. So what the rules and agreement or a regulation that is formed with the other person during the age of a minority, that cannot be ratified. Then the fourth one is, if he has received any benefit under a void agreement, he cannot be asked to compensate or pay for it. So at the time of a minority, if that minor person has received any benefit and that is under void agreement, so further he cannot be asked to compensate or that pay for it, because agreement with the minor is declared as void agreement. We already discussed from that, and that is from the very beginning, that is called as void agreement. So if minor has received any benefit and that is during his minority and that is called as void agreement, he cannot be asked to compensate. That means minor is not liable to compensate that benefit further. The fifth rule, that is he can always plead minority. That means fraudulent representation by minor, no difference in the status of agreement. The contract remains void. So what the fraudulent representation that is made by a minor, that declared as a void agreement. We already said that. Then the sixth one is, there can be no specific performance of the agreement entered into by him as they are void ab initio. So as minor's agreement or agreement with minor is declared as void from the very beginning, so there can be no specific performance of the agreement entered into by a minor person. The seventh rule, he cannot enter into a contract of a partnership. So minor cannot enter into any type of agreement in partnership business. A minor with the consent of all other partners admitted to the benefits of an existing partnership. So this can be possible only when all the other members in the partnership, they give their consent that to act in the partnership business, then that can be liable to act. Otherwise minor can contribute money and take the profit, suffer the amount of loss, but he cannot take any type of leading role in the partnership business, or he cannot be declared as a partner in the partnership business. Then the next point of the rule, that is he cannot be adjudicated as insolvent. As minor, that means everything is under the supervision of their nominee or their any other family members, or that is under the supervision of the court or their guardian. So minor cannot be declared as insolvent, because nothing in the name of the minor, no property or nothing that is in the hands of the or in the names of the minor. So minor cannot be declared as insolvent during the age of a minority. Then the next rule, he is liable for necessary supply or necessary services. That means minor, if that person is under the supervision of any guardian or any nominee members, then what the necessaries supplied by that major person or the guardian to the particular minor person, then the necessaries supplied by the person or the guardian, that person is liable to take all the compensation from the property of the minor if that is under the supervision of that guardian. So the necessaries means food, cloth or shelter, what that has been incurred or made by the major person or the supervisor or the guardian. So the guardian is liable to take everything from the minor's property, or minor is liable to provide all type of a compensation which has been provided for necessaries. Then the next one is, he can be an agent. Minor can be declared as an agent. Minor can act as an agent but not personally liable. Though minor can be act as an agent, but he is not personally liable for acting of his agency during the time of a minority in the business. Then minor is liable in tort. That means any type of a civil wrong, if it is made by the minor, then minor is liable and to make compensation for that type of a civil wrong, which is called as a tort. Then a minor cannot become a shareholder of a company except when the shares are fully paid off and transferred by shares. So minor cannot be declared as a shareholder in a company. He can contribute money in the company by purchasing the shares, but he cannot be declared as a shareholder. He cannot be declared as a partner. He cannot be an agent, but he can liable for the business and contribute money or money's worth. Then next part, that is person of unsound mind. That person is declared as incompetent to contract, and if the person of unsound mind is there, then they are not competent and the contract is not called as a valid contract. So one of the essential condition of a competency of a parties to a contract is that they should have a sound mind. So basically, to become a valid contract or to become capable to enter into a contract or competency of a parties to a contract, the person must be of a sound mind. If the person is of unsound mind, then that person is declared as not capable to enter into contract and the contract is not called as a valid contract. So section 12 defines the definition relating to sound mind. When a person can be declared as a sound mind, a person is said to be of sound mind for the purpose of making the contract if at the time when he makes it, he is capable of understanding it and forming a rational judgment as to effects upon his interest. So there are two parts. One is capable of understanding everything. The second one is forming a rational judgment what the person has been made. So when a person is of sound mind, we can say that the person what he or she makes agreement with any other, that person is of a sound mind when that person is capable of forming that agreement and the person also make a rational judgment as to the effect what he has made the agreement with any other person. If the person is not capable of judging anything and not taking any decision as to his effects, so that person is not of a sound mind person. That is called as a unsound mind person. A person who is usually of a unsound mind but occasionally of a sound mind may make a contract when he is of a sound mind. So occasionally some persons are sound mind and during that time that person is capable to enter into a contract at the time when he is of a sound mind. But usually of unsound means that is does not enter into a contract. Then the second round, a person who is usually of a sound mind but occasionally unsound mind may not make a contract when he is of a unsound mind. If a person occasionally of unsound mind, so during that situation that person is not make a contract of creating a valid contract, or that person is not capable to enter into a valid contract if that person occasionally of unsound mind. So one example is there, a person is a lunatic who is at intervals of a sound mind may make contract during those intervals. So a lunatic person during certain intervals that person is of a sound mind. So during the age of or during the situation of a sound mind situation, that person is capable to enter into a contract or create a valid contract. Soundness of a mind depend upon two facts: his capacity to understand the contents of the business concern, then in that case the person is of sound mind. The second one is his ability to form a rational judgment. So when a person has the capacity to understand the contents of the agreement what he or she has entered into, that person is of sound mind. The second one is the ability of the person to understand everything and make a rational judgment as to its effect, then that person is called as a sound mind, or that is soundness of minds. If a person is incapable of both, that means when the person is not capable to understand anything, the contents, and the person is not able to form a rational judgment, in that case the person suffers from unsound mind. That means that person is declared as an unsound mind person. So what are the grounds under which a person is declared as unsound mind? The first one is lunatic. When a person is declared as lunatic, in that case that is called as an unsound mind person. So who is a lunatic? A lunatic is a person who is mentally deranged due to some mental strain or mental experience. So due to some mental pressure or mental experience, if the person is deranged, that mind is deranged, then that person is called as a lunatic person, and he suffers from intermittent intervals of sanity and insanity. He can enter into contract during the period when he is of a sound mind. So when that lunatic person having a sound mind, that means judging anything and having capability of understanding anything, in that case that person is capable to enter into a contract. The second one is idiots. An idiot is a person who has completely lost his mental power. So when a person has completely lost his mental power, that person is declared as idiot person. He does not exhibit understanding of even ordinary matter, even a singular simple matter or ordinary matter, that person is not capable to understand anything. Idiocy is permanent lunacy that denotes periodical insanity with lucid intervals, and agreement with an idiot like that of a minor is void. So when one agreement has been made with an idiocy person, that means that is similar to agreement formed with a minor, and that is called as a void agreement from the very beginning. Then the next one is drunkenness or a intoxicated person. This person is also coming under unsound mind. A drunken or intoxicated person suffers from temporary incapacity to contract. So when a person is declared as a drunkard or intoxicated, then temporarily lose his mental power, and at the time when he is so drunk or intoxicated that he is incapable of forming a rational judgment. So the time at which the person is so drunken or intoxicated, in that case that person is not capable of forming a rational judgment, and the position of a drunkard or intoxicated person is similar to that of a lunatic person. Then the next ground, that is mental decay. There may be mental decay or senile mind due to old age or poor health. So this situation arises on account of old age or poor health of the person, and when such person is there, that person is not capable to enter into the contract and does not understand anything to the contract and its effects upon his interest, and that person is declared as a unsound mind person, and that person cannot enter into a contract. Then the next one is hypnotized person. Hypnotism that produces temporarily incapacity till a person is under the effect of an artificial induced sleep. That means when a person is continuously in artificial sleep position and temporarily loses everything, that person is called as a hypnotized person, and hypnotized person incapacity temporarily loses everything under the effect of an artificial sleep, and that person is declared as unsound mind person and not eligible to enter into the contract. And there are certain other categories where the person is disqualified from contracting any law. So the first one is alien enemies. An alien enemy means the subject of a foreign state. Alien enemy or alien is a person who is not subject of the Republic of India. That means outside country's person, they are called as the alien for our country, and he may be alien friend or alien enemy. So that alien is maybe an alien friend or maybe alien enemy, and they are not contracting to any contract with our country's legislation or rules and regulation. Then the second one is foreign sovereigns or diplomatic staff or accredited representatives of foreign states. They are also not qualified to enter into our contract or rules and regulation. They have the some special privileges and generally cannot be have sued unless of their own submit to the jurisdiction of our law court. but an Indian citizen has to obtain a prior sanction of a central government in order to sue them in our law court. The foreign sovereigns or the diplomatic staff or any representative from foreign states, they are not capable to enter into our Indian country's laws and rules and regulation, but an Indian citizen, they have to obtain prior sanction from central government in order to sue them in our law court. Then the third one is corporation. Corporation being an artificial entity, it is created by human beings having separate legal identity and existence. So as it is an artificial person created by law having some legal existence, they are apart from the members and they are purely disqualified from contracting any law. It may come into existence by a special act of legislature or by registration under the Companies Act 1956. Then insolvent. Insolvent means when a person is not capable to pay its debt obligation, or even if their private property is not sufficient to meet all types of a debt obligation, in that situation the court declare that person as insolvent person. So when a debtor is adjudicated as insolvent, his property vests in the official receiver of official assignee, and as such insolvent is deprived of his power to deal in that property and permanently disqualified from contracting any law to any other persons. Then the next one is convict. A convict when undergoing imprisonment is also incapable to enter into contract with any other person, as certain case is under their jurisdiction or that is under consideration and that person is on imprisonment, so that is incapable to enter into a valid contract. Then the next one is married woman. A woman is competent to enter into a contract only for her separate or personal property, but she is not allowed to contract for her husband's property except in special cases or circumstances. So generally a married woman is only liable for her separate property or for her personal property, but that married woman is not allowed to enter into a contract or to share the property of her husbands, and except in certain cases that person is not allowed, or married woman is not allowed to enter into contract. So these are the some of the grounds under which the person is adjudicated as not competent to enter into contract. One is minor, second one is person of unsound mind, and the third one is person disqualified by law. So this is various criteria or the situation where the person is not competent to contract. If the person is not competent to contract and they are not capable to enter into a valid contract, or the contract which they formed, that is not called as a valid contract. So this is our today's discussion regarding to competency of parties or capacity to parties. Hope you all students have cleared about our lecture class. Still if having any doubt, you can give your comment in the comment section. Thank you. Have a good day to all of you.